Okay, Assalamualaikum warahmatullahi wabarakatuh and good evening everyone. So this is our second, recorded lecture or online lecture, okay, synchronous for the final topic for this semester, okay, which is general defenses. And now we are already in part two, okay. Part one we have covered last week, okay. For part one, we discussed three slightly longer defenses, okay. We started with volunteer and fit injury, and then we proceeded to illegality, and then the last one last week, okay, was the topic inevitable accidents. Okay, so for tonight, you don't have to be worried because not many slides actually. Okay, I have just gone through the slides. So roughly there are around 30 slides, okay, with content. So, and then it will be covering another five differences, but just a short one, okay, short discussion for each of the difference for part two. Okay, let us proceed. Okay, as you can see on the screen, okay, there are altogether five, okay, that for us to look into tonight, especially the rule, okay, the meaning, the rule, as well as some of the decided cases, okay, to show to us the application. Of course, most of the cases are from common law, but we also have some local case, even though just a limited local cases to show the application. All right, as you can see on the screen, it will start with acts of God, and then the second one will be private defense, and then necessity, statutory authority, and the last one will be mistake. Okay, let us start with the first one. All right, the defense of acts of God. Actually, later when you do your law of contract part two, okay, you will also come across this defense because it's relevant to torts law as well as contract law. Even the case law that we are going to discuss after this, it was argued or based or filed based on the two grounds, okay, which is contract law as well as torts law. Okay, as far as the defense of acts of God is concerned, okay, usually the court is so cautious, okay, so hesitant to allow for its application. So having said so, we don't have many cases in which the defendant could successfully argue, okay, based on this defense. So it's very limited application. So it's very favorable, less favorable as far as the court's approach or attitude is concerned. Okay, the court is so hesitant. Okay, the court, it's not favorable for the courts to allow the defense, okay, to be pleaded by the defendant. What's the reason? One of the strongest reason was that the advance, okay, of our current or modern technology, okay, and whatnot, and what more. Nowadays we are into AI, okay, artificial intelligence, so all those technology. So that's why the court is so reluctant, okay, or it is something which is not favorable, okay, among the courts. And then what are the things to be proved in case a defendant still want to argue or wants to plead this particular defense in order to be absolved from liability? First, okay, must prove, okay, must convince the court that the damage or losses occurred, okay, it happened or it occurred through natural causes, and then it is something which are unforeseeable, okay, and then no human intervention at all. So this rule is taken from the case Standard and Earl of Glasgow. So this is the rule or ratio that we extract from this particular case. Okay, let's go to the next slides. All right. As far as the rule is concerned, okay, there is actually one specific test, okay, in order to see whether it is applicable or it is relevant or not, okay, whether the defendant could succeed, okay, to plead this particular defense. So the test is that first, whether a foresight and rationality may comprehend, okay, the possibility of the event occurring or whether it's possible. And another one, okay, or whether the event, okay, whatever as I've got here, okay, could have been reasonably anticipated or prevented. It is something which could be anticipated or could it be prevented by whatever safeguards whatsoever. So having said so, the next rule is that natural danger, okay, natural occurrence, okay, will escape through natural cause. So then this is something which is considered as acts of God. Okay, everything must be natural cause, natural danger. But if it is natural cause, but there is elements of artificial danger. I mean, danger is created because of the human interference or intervention here, then it's very, very hard, okay, to plead or to succeed under acts of God defense. So we have, I think we have two cases. All right. We have three cases altogether, but we'll start with local case. This is actually a case, judgment by federal court. You are going to learn this case in your contract part two later. Okay, it's the same case, exactly the same case. Okay, the case name is Kwan San Ming and Cha Chi Hing. Quite old case, 1965. Okay, so the suit was pertaining to asking for compensation damages, okay, for breach of contract, okay, just like I said just now, as or alternatively, okay, compensation damages for negligence. So it happened due to, I mean, it's related to a contract of towing, okay, to tow certain logs from one destination to another. It happened in Sabah, okay, and then when the appellant was being sued by the respondent here, this is a appeal case, okay. The difference was that, okay, this lot, okay, the number in terms of number 253 lots, okay. I mean, this number of lots here were lost, okay, in a storm. That's the keyword here, okay. As I've got here is storm. Storm so violent. So that's why appellant said, well, this is actually acts of God. And then I should be excused from all liability for damages. I mean, this is argument by the defendant. I mean, he doesn't want to pay for the compensation for the missing or lost lots here. But the judge, the trial court, or even federal court judge later held that although there was a storm, yes, we agree there was a storm at sea, but it was not a storm violent enough to be regarded as an act of God. Okay, and then defendant lost the case. I mean, the court didn't allow the defense, and this is the quotation from the former Chief Justice, okay, Wiley CJ. So he said that this is actually the rule. Okay, I mean, the court made it clear how to apply, how to succeed if the defendant want to plead for the rule. So an act of God, okay, in the legal sense of the term, it can be or may be defined as extraordinary, not ordinary, extraordinary occurrence, and then could not be foreseen, and then could we can't do much about it, cannot be safeguarded, cannot be guarded against. Okay, or in other words here, okay, accident, whatever event here, storm for example, it happened due to natural causes, directly, exclusively, without human intervention, and cannot be avoided by any amount of foresight or pains, okay, or care here. I mean, if we were to look closely, look deeper to the facts of the case, towing here, all right, actually, it is still avoidable. Okay, I mean, there should be a way in order to avoid the missing lots in the storm, because storm at sea is something which is quite a norm. Okay, it happened quite often. Okay, that's why the court said, well, this is not violent enough. Okay. All right, let's go to common law case. These are all the landmark cases. We have two cases, but different judgment. All right, the first case is Nichols and Maslin, 1876. This is one of the rare cases in which the court allow the defense of acts of God. And take note of the year. Okay, it happened in 19th century, in those days. I mean, we cannot call this is AI world, internet world, or modern technology world here. Okay, so here it involves rainfall. Okay, but over there in the Western country, maybe heavy rainfall is not a norm. Okay, they are not tropical country. So a heavy rainfall, it caused the embankments of defendants' artificial lakes. So defendants own certain lakes. I mean, he built he created these artificial lakes. So because of this heavy rainfall, so the lake, I mean the embankments collapsed, okay, and the water overflow. So the water from the lake swept away four bridges. Okay, not one, two, but here four. And the bridges belong to plaintiff. Now plaintiff sued defendant, okay, for negligence. All right. So the court applied the acts of God. I mean, the court allowed the defense here because when it happened, it was not reasonably foreseeable. Maybe it never happened in the past. Okay, previously it never happened, and because of that, defendant was not negligent. So defendant was absolved from liability to pay for the compensation for the damage for bridges here. But then later, okay, in 1917, okay, here, Nicholas Marsland, 1876. But in 1917, the courts, when deciding another similar case, disagreed with this particular decision. So the case, all right, Greenock. Okay, I mean the later case, the name is Greenock Corporation and Caledonian Railway. Again, it involved heavy rainfall, and then this rainfall, it caused defendants pool to flood. And now the overflow water, okay, water from the pool flowed to highway and then flowed onto plaintiff land. So it caused damage to plaintiff property. And then again, okay, when the plaintiff sued the defendant raised the same issue. I mean, raised the same defense. Sorry, same defense. Defendant used the defense of as of God, but the court did not accept the as of God, and the court held you were negligent. Okay, I mean, defendant was negligent. So what's the reason of having such a judgment here? The court said, okay, I mean, it's all about your activity. Okay, you are the one who collect and damming up the water. This is not natural. Okay, and defendant as the one who created the pool. Okay, here had a duty to ensure that people of lower ground, this is upper ground. Okay, lower ground will not be injured or adversely affected as a consequence of their activities. So activities of damming up the water. So it's very foreseeable that if there is any heavy rainfall, it might overflow and it cause damage to the people who were staying at lower ground. Okay, and then the gist or the keyword from the reasoning or the ratio here, interference. So what's interference here? The activities of collecting and damming up the water of a stream. I mean, in order to gather or collect the water, channel the water to the pool, okay, belonging to the defendant. So interference in this case creates such duty on defendant. So meaning that here for the first defense for tonight, as of God, you have at least three cases. Okay, one local case, two cases from common law. Okay, let's move further. We are done with the first one. The second one, private defense. Important, okay, a very important defense here. Right, but another word, similar word would be self-defense. So you might use the term interchangeably. Okay, it's either private defense or self-defense. So, I mean, in what situation it might happen here? It is actually natural, okay, for us, for human being, okay, to defend, so to protect ourselves, okay, to survive, for the survival, or even whenever we are being attacked, okay, repeated strikes. So of course we are going to do whatever necessary in order to defend ourselves. Okay, it's private defense or self-defense. So for this particular rule, okay, we have two tests or two requirements or two conditions here, or two questions to be asked. Okay, the first one, is it reasonable to apply violence, okay, on the part of the defendant because he's protecting or he's defending himself? And then if the answer is yes, okay, the second test or the second question, is the violence, for example, to strike back or to hit back, okay, is it proportionate to the strike? Or is it in terms of weapon, is it proportionate or not? In terms of strength, in terms of age, is it proportionate or not? Okay, if the answer is yes, then yes, the court will allow the defense of private defense. But let's say the answer is no to any of the questions just now, then the court won't allow the defense of private defense. In order to make it clear, let's have a look at case law. How many cases that we have? Okay. All right. Again, for private defense here, actually, it could be further divided or classified into two. Okay, to defend human body, okay, physical, or to defense property. All right. So the first one, defense of person. All right. So another question to be asked. Okay, is the danger, okay, imminent? I mean, the whatever situation, okay, for example, the beating up, for example, okay, the fight, is it really the imminent danger? Imminent is like it's about to happen. Okay, is it really critical, urgent? Okay, in that situation. So we have a case, a good case, Lane and Holloway. I mean, reported in 1968. Of course, this is a common law, a landmark case. So it involved a fight. Okay, actually the fight, physical fight, it started from exchange of words lah. Okay, words exchange between plaintiff and defendant's wife. It started from the exchange of the word, and then after that, okay, plaintiff hit defendant on the shoulder, and then defendant retaliated. Okay, we also, I mean, usually we use the word retaliate. Okay, causing plaintiffs to suffer injury, and it requires many stitches. So I read few reports. Okay, they use different number of stitches, 16 or 18 or 19. So between 16 to 19 stitches, but it's very severe injury. And then the judge who decided this case was Lord Denning, the famous Lord Denning. So he said, okay, defendant should not have taken plaintiff words as a challenge, okay, due to their age difference. So the court look at the age, okay, to see whether is it proportionate. And then the violent retaliation, okay, was something which was so unreasonable and it's not, I mean, it wasn't proportionate. So that's why the court didn't allow the defense of self-defense, even though the one who started the fight was plaintiff. Okay, but then when he was being hit, okay, by defendant, I mean, it wasn't proportionate, so it wasn't fair to him. All right, let's have a full, I mean, for clearer case. I mean, what happened actually? I mean, how old were the party here? All right, the plaintiff, the claimant of plaintiff, sorry. So he was a retired gardener, and then in terms of age, he was 64. So you can imagine how old he was. Okay, so and then there's a fight. But then on the part of the defendant, how old was he? 23. So you can imagine. Not even now. I mean, it's like triple the age kan? Almost, okay, 23. So this young defendant, okay, he owned a cafe. Okay, in terms of location, it was so close to the house of the claimant, house of the plaintiff here. And then it was frequented, okay, visited by youths late at night, and then it created noises. Okay, so the plaintiff was against, okay, this behavior, and then they are not on good terms. Okay, I mean, they're having some tension relationship here. And then one unlucky night, okay, here the claimant, the plaintiff, okay, the retired gardener, okay, he shouted not so nice words, okay, to the, not to the defendant, but to the wife. I mean, he couldn't take it anymore, so he shouted whatever words here. But it happened outside the house, okay. And then the husband, okay, the 23-year-old, okay, the defendant, he was actually in bed at that time because very late at night, okay. So he got up and he went outside the house in his nightgown. I mean, it's reported in the case, okay, the facts. And then the claimant, the retired gardener, the old man, okay, he thought the defendant was about to punch him, okay. So he punched first. I mean, he started the punch. Can you remember he started the words? Now he started the punch because as if he thought, oh, he's about to be punched, so better he punch first. And then but it's just a minor punch lah. I mean, just a mild one. So the defendant struck the claimant and it hit the eye, okay, and it caused severe injury. So claimant received, I mean, another report 18 stitches, okay, another one 19 stitches. So it required surgery. So now that's why now the old man, okay, the retired gardener, brought action for damages. So at the lower court, actually, the court allow the defense, but when the case was brought to I mean higher I mean appeal level, so Lord Denning said, well, this is something which is not proportionate. I mean, because of the age and then also the violent, okay, the force, okay, when the gardener or when the old man was being hit. I mean, it shouldn't happen that way. Okay, so this is the case in which, example, the test is not being fulfilled. Okay, let's go to another situation. Just now, defense of person. Okay, I mean, private defense or self-defense. Now to defend property, defense of property, also private defense or self-defense. The case is Holmes and Beige. Okay, Bagge. I don't know how to pronounce it. Okay, Beige or Bash, Beige. Okay. And then here, one of the argument, okay, raised by the party, by the defendant here, defense of property, okay. But then the rule is that this defense of property can be raised by someone, okay. But the condition is that you must have right of possession to the property. You must possess the property, then only you can raise the defense of property. I mean, you are defending the property because you possess it. Remember, possession is not equivalent to ownership actually. Possession is slightly lower compared to ownership. The thing that you possess, maybe you don't own, but usually if you own, then you possess as well. But sometimes you own, but you don't possess. So, I mean, it's not really equivalent in the eyes of law. Okay, but a layman term, possession and ownership are quite similar. Okay. All right, what happened here? Plaintiff and defendant both were members of a cricket club. So again, it involved cricket. And then plaintiff was forcibly removed from cricket field. I mean, against his wish. He was so annoyed. Okay. I mean, when he was being removed, chased out from, and this is based on defendant's instruction or direction here. And later, he brought the suit against the defendant for assault, but defendant said, well, I was defending my property. He argued the defense of property, but the court held that you cannot raise this defense because you don't own the cricket club. Okay, the cricket club was jointly owned by all the members or committee of the club, not you alone. So that's why the court said, well, you cannot succeed in using this defense. Okay, you're not defending the property because you don't possess the property. You are the members, but you do not necessarily possess the property. Okay, another case for defense of property, interesting. Okay, you can see the picture there is about sheep. Okay, sheep. So Creswell and Searle, 1947. So it's between dog's owner and sheep's owner. So plaintiff dog chased defendant sheep. So the sheep was pregnant. So the sheep became miscarriage. Okay. So now, because of that, defendant, the ship owner, shot, okay, plaintiff dog to protect the ship actually, okay. So now the defendant, when he shot, so he was being sued, okay. Now he argued the defense of property. He was defending his ship. So the court held that yes, you can win provided you prove or you satisfy these two tests. The first one, whether the ship was in actual and imminent danger. Yes, okay, they were. And then if the dog is left at large, nobody, it's not being chained or it's not being put in a cage, okay? So it will leave the sheep in constantly imminent danger. So yes, the court agreed and the court approved the defense. The court allowed the defense of property. So for earlier cases now, this one did not succeed. Okay, here, yes, the defendant succeeded in arguing the defense of property. We are done with the second one, okay, private defense. Let's move to the third one for tonight, defense of necessity. Okay, right. So necessity, usually it will be relevant in situation involving altruistic. Unselfish. The meaning is you are not selfish. You are not protecting yourself, but you are protecting others. So unselfish concern for the welfare of others, okay, or other people, or even other people's property you want to protect or you want to save. Okay, so again, similar requirement just now, there must be great danger, okay, must be imminent. And another requirement, whatever act here, to justify the act here, it was done to save life. After all humans have only one life, okay? It's not like cats which have 9 lives, okay? So the moment you lose your life, then it's gone forever. So we have to save life. So that's why the court allow the defense of necessity. But again, it's very, similar to acts of God, it's very limited application. The court is so cautious and it is only allowed in urgent situation. Okay, it involves imminent peril. Okay, whether there must be actual danger. So then only you can argue the defense of necessity. So in modern time, in today's world, present world, usually, this defense is relevant for medical and surgical cases, especially if the patient cannot give consent. So, but the doctor wants to save the life, so proceed without consent. So later, let's say the doctor is being sued for trespass, for example, okay, or whatever, or for assault, for example. So yes, this defense of necessity could be raised because why? Whatever doctor did, actually, treatment here was given based to save life, okay, for the defense of necessity. So again, for necessity is either private or public necessity. It depends on the situation. So we have two cases for the defense of necessity, both from common law. The first one, Cope and Sharp. Okay, take note of the spelling. Cope and Sharp, 1912. Here, remember, okay, necessity is to save the life of others or property of others. So there was a fire on plaintiff land, and defendant, he stepped in onto the land. Okay, in order to set fire to Hida is a bush, okay, to protect his business, okay. And then the small fire was to prevent larger fire. That's the action, okay, from spreading to nesting pheasants on defendant's land. Bird lah, basically here. All right. And because of that, plaintiff sued defendant for trespass to land. Okay, why you must step onto my land here? Okay. The court held that defendant was not liable because in this situation, in a fire, okay, there was a real and imminent danger at the moment. And therefore, whatever he did here was reasonably necessary. Okay. All right. Compare with this one, but this one also the court allowed the defense of necessity. Okay, sorry, necessity. Just now I mentioned necessary. Necessity. Okay. Rigby and Chief Constable of Northamptonshire. Okay, here again one district in UK. Right, so now the suit is again policeman. A dangerous psychopath, okay, he entered plaintiff shop and the police was there. So the police want to chase him out. So to flush out that person, that psychopath, okay, the policeman, the defendant, he fired a canister of gas, okay, into the shop. And the act here, okay, the gas, okay, caused a fire which damaged the shop. So now the policeman was being sued, and now here is the defense of necessity. Okay, so the court held that necessity. The court made it clear. Okay, if there is any negligent act, then cannot raise defense of necessity. But for this particular case, okay, I received a reminder. Zoom will end in 10 minutes. We'll see whether we can finish within 10 minutes. Okay. But if we cannot finish, then we are going to resume. We are going to finish all the 30 slides tonight. Okay, inshallah. Okay, the court said, well, in order for us to allow the defense of necessity, there mustn't be any elements of negligence here. So for this case, yes, okay, the court allow the defense, and there's no negligence on the part of the police, even though there could be alternative of using new CS gas device. Okay. And then if the police use this device, then it was fire risk free. It won't cause fire. But for that particular situation, maybe this the latest gas device was not available. So firing a canister of gas, not CS gas, still doesn't amount to negligence on the part of the police. So the defense of necessity was being allowed by the court. So both cases, Cope and Sharp and Rigby here, the court allowed the defense of necessity. Okay, one before last. Okay, the last one will be mistake. Statutory authority, whatever statutes, okay, relevant statute, which absolve the defendants from being liable. So, we might have a list of statutes. So, I'm giving two, okay, two, which could be relevant for tortious action. For the first one, Section 19 Civil Aviation Act 1969. Remember, you notice or not, okay, sometimes you can see that the flight, okay, or the aircraft, okay, it flew over certain height, kan, above the house, okay, all right. So basically, whether the house owner, for example, can he take action based on trespass to the air or trespass or nuisance here? But basically, this particular section, it exempt whatever aircraft here from liability, but provided, okay, the height is reasonable. Okay, it won't amount to act of trespass, okay, for the aircraft to pass by above, okay, the a certain height. Right, so this is the provision. All right, another relevant provision, important one, Street Drainage and Building Act 1974, especially Section 95, subsection 1. It exempt public civil servant, okay, from being liable, okay, provided whatever things they did, okay, to discharge their duty in bona fide, okay, bona fide lah, good faith. All right, and Section 95, Section 2 as well, okay. Strong word used here, okay. It used shall not be subject to any action. No liability, okay. If whatever act here is for the purpose of inspection and approval, okay, of the local council. So it's a strong protection or immunity given to state authority as well as local authority here. And then remember we discussed the case, involving collapse of Highland Towers, okay. So MPAJ, Majlis Permandangan Ampang Jaya, Stephen Pua, Cheng Lun, okay. Here, there are many suits were taken by affected victims, okay, and this is one of the suit. So after the collapse of Block 1, okay, of Highland Towers, and then MPAJ, local authority, they promised, okay, that yes, we are going to provide master plan, okay, master drainage plan, so that we are going to implement, all right, to ensure stability and safety of the adjacent block 2 and 3, because block 1 already collapsed. So what's next? They prepare master drainage plan in order to avoid the recurrence of the collapsed building here. But whatever plan here, they failed to carry out the plan. So it caused certain losses, okay, after the collapse of the building. All right, so respondent, because this is appeal case, okay, respondent file a suit in the High Court against various parties. We have many parties involved, including MPAJ as the fourth respondent, okay, and what's the tortious action here? Negligence as well as nuisance, okay. So the trial court held that yes, MPAJ was 50% liable, but MPAJ appeal, okay, appeal, and but the court still affirmed the decision. I mean, the court granted immunity. Okay. I mean, but immunity here, the court divide it into two. Okay, is it pre-collapse, before collapse, or is it after post-collapse liability? So basically, the court said, trial court, high court, as well as court of appeal, said, well, immunity is only given to whatever pre-collapse, before the building collapse. But whatever happened later, or whatever plan later, so you could be liable. I mean, no protection for MPAG for post-collapse liability. But then when the court, when the case went up to appeal, went up to federal court here, the court the court eventually, if you read, local council cannot be held liable. I mean, that's the ultimate finding. The court allowed the immunity. I mean, no liability even after collapse. Okay, pre-collapse and after collapse as well. I mean, lots of argument, but this is the focus. I mean, there's a statute which absolve certain state authority or local council from liability. So very strong provision. Okay, I'm not sure whether we have time. Okay, we have 4 minutes left. I think we can make it. Okay, the last but not least, mistake. Okay, very straightforward. The final defense, okay, that the party or defendant might raise, okay, whenever he's being sued. Okay, mistake of fact. I mean, mistake could either be mistake of law. I mean, mistaken about law, or the maxim is ignorantia juris non excused. I mean, no excuse if you are ignorance of the law or making mistake with regards to law. But mistake of facts, maybe the court will allow, but very, very limited application. Okay. And if it relates to conversion, okay, conversion you are going to learn in your part 2 later, talks 2 later. Actually, it is civil term for theft. Okay, because conversion, you file a suit asking for compensation. For theft, of course, a different, criminal proceeding, okay, different altogether. So we have this case, Consolidated and Curtis. So here, auctioneer, okay, he was mistaken. He sold off the goods because he thought it belonged to someone else. Okay, and then he did it mistakenly. But the court said, no, you are not being protected. Okay, here, so you can still liable for conversion. I mean, mistake was not accepted as a defense, even though there was a mistake in as far as auctioneer was concerned. He can still be liable for conversion. Okay, last case for tonight. All right, Cheng Han Guan. You are going to learn this case as well, or you have learned in is it in the under contract law? Okay, under promissory estoppel, I think. Right, Cheng Han Guan and Perumahan Farlim. Here, it involves tenant, okay, as well as developer. So tenant doesn't want to move out from the land. Okay, they have the right to stay there, but the developer thought, they can forcibly move the tenants. I mean, they can just started the whatever development project here. Okay. All right. So the developer, defendant, they carry out the demolition work. They want to demolish everything. Okay, here, and because they thought they are entitled to do it. Okay, mistaken view of the law. I mean, they thought they have the self help. So under the law, remedy, one of the remedies is self help. I mean, you help yourself. You do whatever necessary in order to chase out the tenant. But actually, this is mistaken belief. Okay, so the court said, no, this is not a good defense. Okay? Even though you thought you have the right to self-help, but it's not a good defense, okay, for action for trespass. So still, developer was liable for trespassing onto the tenant's land. I mean, the tenant has the right over the land, even though for certain period of time, even though they are not the owner, but they possess the land as tenants. Okay. Alright, so Cheng Hangguan, I mean, the tenant won the case. Okay, the court allowed the plaintiff claim, and then that's only the explanation of trespass. You are going to learn trespass in detail in your thoughts too. Okay, alright. With that, okay, this is just a revision. You need to do revision on your own. So we have completed the syllabus. Okay, I stop share and I stop record. Stop recording.